morning, everyone. Today is April 6th, 2023, and welcome to the New Possibilities Hour, part of the Will Work for Food project founded by Natalie Armstrong-Motin in the spring of 2020. Every Thursday, Jean Lawler and I are delighted to present another cutting-edge webinar for mediators, arbitrators, lawyers, and anybody who negotiates. As you know, there's no charge for these great presentations. Rather, we ask you to contribute a comfortable amount to a food bank if you like what you see. And every week, one of my favorite parts of the presentation is when we announce the running total of just how much our generous audiences have contributed in honor of our great speakers. Jean Lawler, would you please do the honors?
Well, good morning, everyone. Good morning, Jeff and Natalie and Jennifer. It's great to be here today. Our total of donations, of which we have been told, and these are to food, these donations are, of course, to food banks around the world, $378,161.42. It just keeps growing exponentially. And thank you so much. Your generosity is amazing. And $400,000 is right in sight. So thank you so much, all.
Fantastic. Thank you. And we have another wonderful presentation coming up today with Jennifer Keller of the firm of Keller Anderle LLP. Anybody who knows Jennifer knows she is one of the most distinguished trial lawyers in the country. She has tried over 150 cases to verdict, including intellectual property cases, bad faith, breach of contract, white-collar criminal, ADA, education law, fraud, and almost anything you can imagine that would wind up in front of a jury. She represents both publicly and privately held companies, as well as high net worth individuals and celebrities. Her plaintiff verdicts and settlements total over $1 billion, and she has successfully defended bet the company cases as well. In 2022, she famously secured a defense verdict for actor Kevin Spacey in a trial in the Southern District of New York alleging molestation. Jennifer is a fellow of the American College of Trial Lawyers, was elected to the California Lawyers Association Trial Lawyer Hall of Fame. She's a Law Dragon legend. She has won 3 California Lawyer Attorney of the Year awards in 3 different years in completely different fields. She has been named 15 times to the Daily Journal's list of the top 100 lawyers in California, and she is ranked Band 1 both in Chambers USA and Chambers Global for trials of all types, nationwide, if not worldwide. Jennifer, we understand you're going to be speaking to us about a very important topic today. Welcome back to Earth, bringing client expectations back into the zone of reality, a very important yet little discussed aspect of the ways that lawyers and mediators collaborate to the benefit of clients. Jennifer, please tell us a little bit about the food bank to which you would like people to contribute if they're able. And then we're very much looking forward to your presentation. The floor is yours.
Well, thank you, Jeff, and good morning, everybody. I know that most of you have never had an unreasonable client or a client with unrealistic expectations, so I don't even know why you're here. But I've had a few, and so I thought this might be a good topic to discuss. As far as the food bank, I'm asking you to donate today to the Second Harvest Food Bank, which is Orange County, California's largest food bank, and has served tens of thousands of clients over the years. And I know right now they're facing acute and critical shortages of food with the ending of various COVID era programs. So thank you all for your generosity. We really appreciate it. Now, I guess I'll just launch right in. Almost any party in litigation can have unreasonable or unrealistic expectations. Plaintiffs, defendants, sometimes insurance adjusters who may not be parties but hold the purse strings in many cases. Just about any kind of party or participant you can imagine can be unrealistic. And the reasons for that are many. Sometimes it's as simple as they've read about a case that they believe is similar to this, that had a huge verdict. Sometimes it's emotional. People can get emotionally embroiled in disputes. Let's say it's a dissolution of partnership dispute, which I've handled a number of. And the partners go way back together. They had personal as well as business bonds, and their feelings of anger, hurt, betrayal. Sometimes the emotions are simply greed. You can have a party who unrealistically believes that this litigation is going to get him or her out of all the financial troubles that they've ever had and set them on the path to a great life. And unfortunately, the case doesn't support that belief. But this is what they clung on to because of their circumstances. There are just all sorts of reasons why people can be unrealistic in evaluating the case. This also goes for corporate defendants or corporate plaintiffs. You sometimes will be talking with people in-house, and maybe the person closest to the case in-house gets it and understands the potential risks to the company, but maybe that person's boss, either in the legal department or higher up, does not. So one of the things that you find also is some clients believe that if they just pick the right lawyer and pay them enough money, they will win. And they don't understand that facts in the law actually do drive outcomes. So the client will tell you, I'm paying you a lot of money. I expect you to get exactly the number that I want. And that can also be a problem. So sometimes it's a non-emotional evaluation of the case, but the person's simply wrong. Their evaluation just isn't on point. They think it is. They think they're being rational about it. Maybe they don't have any skin in the game. And you'll see this with adjusters sometimes. Insurance adjusters will just come up with these lowball figures that they think should be sufficient. And they may not, they in turn may not even be driven by the facts. They may be sometimes driven by just a general skepticism of plaintiffs or a dislike of this particular plaintiff's lawyer. Lots and lots of reasons. I have sometimes referred to mediation for the emotional clients. I've sometimes referred to mediation as the first day of Festivus. For those of you who've watched Seinfeld, you know, the airing of grievances is a big part of Festivus. And mediation can be a time for that airing of grievances. So one of the things that we need to remember as lawyers is a lot of times in mediation, we really have to take off our adversarial hats, and we have to look at things from a completely different point of view. It's really hard because we're trained as litigators to be adversarial, and we want to get in there and fight and show how crappy the other side's case is and how great our case is. That may not be the best thing for your unreasonable client, to have fuel thrown on the flames. That client may need to be hearing a much more balanced view of the case than you can provide. And maybe you're having trouble presenting the facts, the black and white of it to the client, because you don't want to impair your relationship with the client. You don't want the client to say, well, you don't have any faith in my case, faith in me. So these are all reasons that a mediator can help you. So how do you get to mediation? Well, it can either be court order or it can be voluntary. When the court tells me that I have to go to mediation, if I really think the case has a shot at settling, then I usually want to select the mediator. I don't want to go to, particularly in federal court, where you're offered a magistrate judge, and they can be great, but they have huge caseloads, and they want to cut to the chase. They want to see if they can get it settled quickly, and if they can, a lot of times that's the end of the story. Sometimes the state courts, depending on your county, will have dedicated settlement judges, and they block out more time. But generally, I want to pick the mediator. This is the first thing that you do in achieving that objective. Is the objective to get your client who's unrealistic or unreasonable to see the light. Is you want to see if you can get the other side to agree to let you pick a mediator your client is comfortable with. Now, I find that often, again, the selection of the mediator becomes combative and adversarial, and each side feels they have to win by getting the person they want. It can be pretty helpful to call your opponent and say, look, I think maybe this case can settle at mediation, but my client's gonna be difficult, and it's gonna be very hard to get to anything remotely resembling a number that you want. And I think the best possible approach for you is to let us pick a mediator my client's comfortable with. And particularly if it's, say, an insurance adjuster who's going to be the decision maker who will present the obstacle. Picking a mediator they're comfortable with is very helpful. Somebody that they feel they have a relationship with, that they feel has been, quote, on their side, unquote, in the past, who they trust, whose judgment they think is good. That can be really important. But I find that less experienced lawyers, sometimes they're experienced, they're just not very good lawyers. They don't get it. And so they are very hostile about that. I like to spend some time talking with them about the benefits of that. The mediator isn't going to be making, it's not like arbitration. They're not going to be making a binding decision. The goal is to get a settlement. If your goal is to get a settlement and my client's the one who's got the money to offer, or I have a decision maker on our side who you need you need to come around, then you really have to pick a mediator they trust. And if you don't, you're going to have to work twice as hard and maybe not get there. For me, I'm always willing to listen to that from the other side. If the other side says, if we can just pick Judge, Jane Doe, who my client thinks is the greatest thing since sliced bread, that'll be really, really helpful. I'm for it. I don't say no. It's hard. Like I said, it's hard to take off that adversarial hat. Now, one of the issues that always comes up and that you have to deal with is the ethics of, on the one hand, an unreasonable or unrealistic client's expectations driving how you approach mediation. Because you want, within the bounds of ethics, you're supposed to do whatever you can to achieve your client's objectives, but your client's objectives may be contradictory or unachievable. And I'll give you an example. The client says, I've got to settle this. This thing is killing me. This litigation's killing me, but I'm not paying that bastard a dime. Okay, those are two contradictory statements. Do you, another one, I want them to feel the pain, Jennifer. That SOB has really betrayed me. I want him to feel the pain, but I don't want to pay a lot of attorney's fees. Okay, I want you to file every motion, but I can't afford to run up the bills. There's another, not that you should ever file motions for harassment purposes, but somebody wants something thoroughly litigated and every stone turned over, but doesn't want to pay much in the way of fees. Those are contradictory. Your in-house attorney for the company says, we've got to keep our legal spend down. We've got to keep our legal spend down. So here's your budget. And it's this very small budget. And we really need to settle this, but we can't pay more than X dollars. And it's just a figure that the case will never settle for. It's just not, the case is not going there. Or you're defending and the insurance adjuster is the obstacle. The insurance adjuster is just unreasonable. He understands what the case is about, but he's used to lowballing everybody. Maybe the plaintiff lawyers he's dealing with are constantly caving into his lowball offers, and you're not going to. So he may not be considering fully the cost of defense. He may not be fully considering the increasing danger of what are known in the trade as nuclear verdicts, these huge verdicts that we're seeing in many jurisdictions. So for all those people, mediation can educate the person blocking the settlement, lower the temperature, assist in making a rational decision. So again, I think the step number one is trying to get a mediator your client likes and trusts, if you can. If not, at least try to come up with a process where you're going to get somebody who you think is going to be able to approach your client with credibility. Now, there are times you have an individual client who's very, very emotional, and you really want a mediator who is an empathetic mediator, who you want a mediator who can feel their pain and can bond with them and can, whatever it is that they're was driving them, can understand that. There are other times where the unreasonable client is a dollars and cents person all the way. Empathy isn't here as a major benefit to that client. That client is only going to go for a mediator that they have a lot of respect for, because that mediator's got a lofty judicial title and perhaps has done complex litigation. So again, if you can't pick the one you want, at least try to get a mediator who's going to appeal to your client's specific mindset. The next thing that you really have to do is talk with the mediator beforehand, and often talk with the mediator beforehand more than once. You need to explain your client's mindset, and you need to be frank. If your client is just having explosions of temper behind the scenes with you about this case and how flipped out they are, and they want to destroy this person, rip his guts out, sow the fields with salt, you need to tell the mediator that. You need to tell the mediator, look, I think my client's being unreasonable, but it's being driven by emotion. Or I think the adjuster is being unreasonable and it's driven by inexperience. This adjuster just hasn't handled these kinds of huge cases and is not in a position to evaluate them. You need to let the mediator know about the client's business needs. You may have a client who thinks that litigation is one thing when it's another, who doesn't realize that his business is going to really be disrupted. Various people in the company are going to be deposed. He's going to be deposed. There's going to have to be many days spent preparing the witnesses for deposition. They're going to be having to turn their company upside down, looking for documents, emails, text messages. Your client may not realize that your client's own text messages and instant messages and all sorts of nasty emails are going to end up being revealed in discovery, and that it's going to be potentially embarrassing. It's going to be there are some things maybe out there that are potential time bombs in the case. The client's image of what litigation is going to be different than the reality. The mediator can explain that. The mediator can, after bonding with the client, can talk about the things that are the road ahead. There may be too, I've had situations where I've represented high net worth individuals, and one party, usually the husband, will say, I don't care how rough it is. I don't care how tough it is. And I don't care how much money we spend. I'm not paying a dime and I'm going to get this guy, or I'm going to get every penny I have coming to me. But the client's wife says, I can't handle it emotionally. I can't go through this anymore. This is killing me. It's killing our marriage. It's killing our family life. He's obsessed with it. I need this to be over. So, and I've never done family law, but I'm sure that family law mediations are really, really fraught with emotion. But giving a mediator an advanced look at your client's mindset, what's driving in your opinion, the unreasonable expectations or the unrealistic view of litigation, can really arm the mediator. Because the mediator, you don't want a mediator going in blind, not knowing what they're going to find, not knowing who they're dealing with, not knowing what's driving that person. And you can do that. You can do all this within the bounds of ethics. I always tell my clients that I'm going to be talking to the mediator myself without anybody else on the line, because I've just found historically that that's the best for getting our mediation on track. And I'm going to explain your point of view. And I tell them I'm going to talk to the mediator. It's funny, I've talked with lawyers who actually think that somehow it's unethical to talk to a mediator ex parte. And I've had to explain that, mediation is not, this person is not a judicial decision maker who has binding authority to make rulings. Ergo, there's nothing unethical about talking to your mediator in advance. And in fact, I really think it's almost like mediation malpractice not to do that. You're sending you're not making the most efficient use of time, and you're not arming the mediator with the tools that the mediator needs. So I also think that, again, it's really, really hard to take off our advocate hats sometimes. But when you talk to the mediator, you need to tell the mediator the strengths of your case, but also the weaknesses. A good lawyer does not drink the Kool-Aid of his or her own position. She can see the weaknesses. She sees that where her opponent is going to try to exploit the weaknesses. And if it's early in the case, it's especially important, really, because these things are the landmines that are going to get stepped on as the litigation goes on. And if the mediator is able to explain to the client how that works and what's going to happen and what these weaknesses are, the client may really listen. And particularly, if you've got smoking gun emails that you're going to have to turn over, you haven't turned them over yet. You tell the mediator, look, I want you to see this smoking gun email. We haven't produced it yet. I don't want you to tell the other side about it yet, but I want you to talk with my client about the significance of this. What's going to happen to the case when this comes out? And, the other thing that you need to do is you need to explain to the mediator how you have gotten through to your client in the past. This client is a tough nut to crack, but I've gotten him to agree with me to do X, Y, and Z in the litigation, which he opposed at the beginning vociferously because he thought he knew better than I. But here's how I was able to bring him around. Here's how I was able to persuade him. The other thing you have to do is, in addition to preparing the mediator, you really have to prepare your client. Even if your client is going to argue with you at every turn, you need to lay out the weaknesses of the client's case for the client. And maybe it's, say, proving damages. A lot of times nobody's really disagreeing too much on what happened, but damages. The client thinks that, and whether it's a personal injury case and the client brings up the Taco Bell coffee spill, and look at the millions that person got, I deserve at least that much. Or whether it's a corporate infringement case and they're looking at some patent infringement that has nothing to do with their matter, but this company got $500 million for this patent infringement. That you have to prepare your client by telling them, no, your case is different. Here's why you're not going to get that. Here's why I think the damages here's where I think the damages are. By doing that with your client in advance, even if it's painful, the client's now been prepped so that when the mediator starts saying, I think the range of damages is maybe $1 million to $3 million, not the 100 million to 300 million you think it is. The client will have heard it before. It's not going to come out of the blue. The other thing that I think can be very helpful is you want to search databases for verdicts and settlements similar to those in your case, and share that database with the mediator. This is something that we like to do at my firm. Is you come up with all the cases that could have similarities to yours, come up with a range. Now you have something in black and white to show the client, and give that to the mediator in advance. The other thing I think is crucial is that you have to insist that whoever the unreasonable decision maker is must attend the mediation in person. And we have a lot of Zoom mediations right now, and some of those can work. I mean, every once in a while you have a Zoom mediation that goes surprisingly well, and I've settled cases during them. But those are usually cases where you don't have the wildly unrealistic client or decision maker. I think for those cases, you really want that person there in person. And one of the things that you should also consider, and again, you're taking off your adversarial hat, you're wanting to educate your client. is talking to the opponent about maybe even filming a mini opening statement, just 5-minute opening statement about what you're going to prove in your case. That can be the litigator's version of shock and awe, because you can talk to the client about little bits and pieces here and there that are obstacles you have to overcome. But when they hear a good lawyer present a format that will be similar to the format that's going to be in a courtroom, a compelling version of why they're going to win their case and what evidence they're going to produce, that can really have an impact. But again, you have to be willing to take off your adversarial hat, and you have to get your opponent out of the mindset of, well, I don't want to give away everything. You know, in civil litigation these days, by the time you get to trial, there are very few secrets. I mean, you've given it away. Discovery has turned up everything. You know what the exhibits are going to be. You know what everybody's going to say. You've deposed all the key witnesses. There really aren't any surprises. So, your opponent, if your opponent wants to settle at mediation and is serious about educating your client, your opponent should be willing to do that and should be happy to do that, in my opinion. But that's not always something that the less experienced lawyers are willing to do. I find that the most experienced lawyers, really good trial lawyers, people who really trust trust themselves and are able to manage their clients and their clients' expectations, are usually willing to do that. And I guess, we're going to be doing some back and forth, Jeff and I will, and then taking some questions. So I will just wrap up this initial part by saying that the other thing to remember is that mediation is a process. It's not necessarily just a one-shot thing. Sometimes when you're dealing with an unrealistic client or an unreasonable client, the first mediation session, which the client maybe thinks is going to be the only one, but you should think of as the first one, is the way that you're starting to educate the client. It may take a while for everything to sink in that the client has heard at the mediation, and it may take a while for the client to nurse the client's wounds, because they will be wounded, realizing that their case isn't perfect, that they're not going to get $1 billion, that they're not going to overnight be Elon Musk, that their company isn't going to recoup every penny of all their sunk costs and also get a huge amount of money in addition to that. But you can go back for another session and another session. I've had cases that settled on the 3rd, 4th, or 5th mediation session. And a good mediator will keep the door open and will tell the client that the door remains open, that I'm sorry I wasn't able to get this wrapped up for you today, but I'm not giving up. I think we can get there. I know what your goals are. I want to help you achieve them. And let's stay in touch. And then, I like to keep, if I still think there are prospects of the case settling, I like to keep the mediator in the loop. And many times mediators will call me and say, hey, how's it going? Or I hear you just won a big motion. You think there's any likelihood now that it's going to settle? Or you just lost a big motion. You think there's a likelihood now that it may settle? And we get things back on track. It's a process, it's an educational process more than an adversarial process. It can be a great tool for saving your client money, trauma, because litigation is traumatic, and time. So Jeff?
Fabulous, Jennifer. Thank you so much. A tremendous amount of extremely helpful information, both for mediators and for advocates there. I do have a few questions. Let's start with an ethical question. You talked about speaking to mediators beforehand and saying some things about your client, which might be less than fully complimentary, shall we say. At what point do you imagine the client sort of sitting on your shoulder and thinking, oh my God, my lawyer is saying what about me? do you have, what is your sense of when a lawyer might cross the limit and no longer be the fiduciary, the advocate, the champion, the one who's 100% committed to the client's goals?
Well, I think first of all, you never want to just denigrate your client. And I've seen people do that. I mean, I've talked to other lawyers who will just call their clients names to me, who will say, hey, listen, I'm with you. I agree with you, but my client's a moron or my client's an asshole. And never do that. You never do that. You are that person's champion. I think what you want to do is you want to let the mediator know what's driving your client, because we all have things that drive us, and it's not because we're bad people. The client might be overwhelmed with emotion and feelings of betrayal and anger, and not be able to manage those emotions in a way that allows him to be rational. You're not saying that the client is crazy. You're saying your client, is being driven by emotion. You are not necessarily saying that this insurance adjuster who's completely out to lunch on what the case is worth is an idiot. You're just saying this person is inexperienced or is used to prevailing on lowballing offers, or is thinking he's saving the carrier a lot of money, but he's actually going to cost the carrier a lot of money. You never attack the person. And when it comes to your client in particular, your client may be before that mediator again in the future, particularly if this is a mediator your client has come to respect. You don't want to do anything that will attack your client's character, integrity, or anything else. So you have to be careful about that. But you have to let the mediator know what's driving the unreasonable or unrealistic expectation, or they can't address it.
So many times in discussing those emotional dimensions with lawyers, I get a sense that the client feels they have been treated with disrespect along the way, and that triggers a desire for revenge. And
Yes.
yes, and that sometimes the answer to that is to rewind the tape, if you will, and allow the other side an opportunity to show respect and diffuse the motivation for revenge. And that many times can be the client speaking during the mediation, perhaps in a joint session, and having the folks on the other side listen attentively, respectfully, taking the client seriously. What is your view on having joint sessions in mediations? And the second part of the question, clients' direct participation and speaking roles in those meetings.
Well, everything is on a case-by-case basis. There's no hard and fast rule. That's one of the things about mediation. A lot of it is, a lot of it you have to kind of fly by wire. You're assessing as you go what to do. I have seen clients sometimes, this is assuming you can put the two clients in a room together and not have them immediately commit mayhem. But I've seen sometimes it can be very helpful if the lawyers and the mediator have conditioned each client to the other's point of view, to put them alone in a room and just let them talk without the lawyers. Sometimes I think having the lawyers there with the client, it creates a battleground mentality. And I've seen cases settle principal to principal at mediation once the lawyers withdrew, and we went to the client pantry and noshed a little and had a cup of coffee. But again, it's all about preparation. You have to prepare the client. The mediator has to prepare the client. The mediator has to understand what's driving each side. And a lot of times the mediator, I think, can step in with practical concerns, can say, look, I understand how you feel. What you've gone through has been really terrible for you. I get it. But do you want to prolong the agony? Or do you want to see if we can't stop this now? and let me talk to so-and-so about this. And sometimes the mediator can come back and say, you know, he feels just as terrible about this as you do, which may be the first time the client's heard that. You know, maybe the other lawyer has never shared that with you. And maybe putting them both in a room can result in them working things out. I have seen it. We did that in a case last year. It was a huge legal malpractice case that we had, and we ended up putting my client, who was the CEO of his company, in the room with the general counsel of the law firm. And there had been, you know, the law firm was concerned about an existential threat, its viability, and the client had seen both through mock trial and at the mediation the benefits of resolving it. And the two of them worked it out.
You've also talked about the anguish and agony of being involved in litigation as something people should take into account when considering their settlement positions. It's a difficult thing to quantify. How do you help your clients quantify the impact of the disruption and the mental wear and tear of being in litigation?
Well, again, it depends on the client. If it's a personal matter, we're in the middle of we have had so many huge family disputes, you know, where you've got 4 or 5 siblings fighting over 250, 350, $1 billion, a lot of money. For them, it's really about ripping the family apart. And, you know, in one of those cases, we were able to settle it by talking about the impact on the mother. The mother was being torn to shreds. She was being pulled apart by all the different family factions, and it was destroying her. And she was old and ailing. We weren't able to get through to the siblings about the impact on them and their spouses and their families, but we were able to show that it was literally killing their mother. And so, you know, that's one way to look at it. But then if you're dealing with business people, maybe you have somebody who owns a privately held company and it's a good sized company. I think sometimes just going through your litigation budget with that person. Here's our litigation budget. Here's what's going to happen. Here are all your key employees. I'm going to need 2 or 3 days of preparation for this person, and then a whole day of deposition, maybe more. And then it's just going to keep on going, you know, and here are all the documents you're going to have to produce. And here, when you go through your litigation budget and you go through the disruption to the business, sometimes the mediator's best pitch to the client is just, wouldn't you rather get back to making widgets? I mean, isn't that what you really do? Do you want your business to be all about litigation? Or do you want to get back to doing what you do best? So it really, I mean, I hate to keep saying it depends, but it really depends. Is it a party, a corporate party, an individual? And who's the logjam? You know, who's the decision maker? Who's the logjam? In representing corporate clients, I often find that the in-house lawyer that we work with day to day as a teammate is absolutely understands and is very reasonable and gets it. But maybe the higher ups, who are the decision makers, don't get it. And or maybe they have a different objective. You know, they need a win, but the in-house person knows it's not likely to be a win. but the person above them in the C-suite just isn't willing to spend the time to learn the case. So if that person is present at the mediation, the decision maker, the logjam, that person has to sit there and listen to the facts of the case and the details, and can then caucus maybe with the in-house lawyer and say, is that your understanding? Yep, that's absolutely right. And so the mediator is enlisted, again, to educate. It really depends. I can't even imagine family law mediations. They must be very difficult because I see partnership dissolutions, which are often like marriages. You'll have people who've been partners for 25 years and have built a business together, and they're often family members or best friends, best man at each other's weddings, you know, godfather to each other's children. And now, for some reason, the partnership is blowing up, and it really is. It's like a marriage breaking up. I mean, it's it's often extraordinarily traumatic. And every once in a while, I'll sit there and think, oh my God, just imagine what family law mediation must be like. Oh, that must be really hard. What are the most
Well,
difficult for you in terms of bringing the temperature down?
it's oftentimes a matter of timing, Jennifer. You have to get people at that moment when they are fed up enough with the litigation, the denial, anger, acceptance spectrum, the steps of grieving through which people must go. And when people have lost a business opportunity, or in personal injury cases, God forbid, an eye or a limb or a life, a family member's life, there's denial, there's anger, and then there's acceptance. And there are many times, and the lawyers get a sense when their clients are ready to go from anger into acceptance, and they need the mediator's help. They need somebody's help to get the client to turn that emotional corner. And there are visceral moments in mediation. You can just tell that something has changed from a fresh wound to ancient history. And it can happen just like that. And many times it's the client wants to be listened to, wants to be heard, sometimes by the mediator, sometimes by the folks on the other side of the table, sometimes by a member of their own family, whatever. And the difficult situations are the ones when people are not really, they're still deeply embroiled in the anger stage. And you can't really use logic to combat somebody's emotional resistance to settlement. It's just, as you say, sometimes it's not the first session. That's just the airing of grievances day. Sometimes when I do a probate dispute, I say, oh yes, the first day we're going to hear about being seated at the wrong table at the cousin's wedding 20 years ago. And then the second day, we're going to hear about who gets the factory and who gets the business. And then on the third day, all the emotional residue comes down to grandma's ashtray or whatever. And we spend the third day talking about that. And many disputes follow that general pattern, the airing of the emotion, getting down to business, and then dealing with the residual emotions. Let me ask you a little different question, which is the question of mediators talking to clients outside the presence of lawyers. What is your view of that?
If it's a mediator I like, know, and trust, I'm fine with it. Sometimes you're forced into mediation with mediators you really don't know and haven't developed a relationship with, and maybe don't get a warm, fuzzy feeling about. I might not be as inclined to do it, but with most good mediators, I don't have a problem with that, because again, I've prepared the mediator. I've told the mediator my point of view, my client's point of view. I've prepared the client. I've tried to get the client to understand what mediation's all about, what the benefits are, what the weaknesses of the client's case are, what he has to lose, the risk-benefit analysis. And and sometimes the client feels that he has to keep up. I know I keep saying he, and it can certainly be a she too. I had a very, very difficult client who, a she, who was every bit as intransigent as my most intransigent male clients. But sometimes they feel they almost have to keep up the same attitude in front of you that they've shown in the past. They feel that they would lose face with their own lawyer if they quit being as gung-ho and adversarial. And they feel like maybe the lawyer would lose some of the lawyer's sharpness if they back off at all. Whereas with the mediator, they can let down their hair a little bit. They don't have an existing relationship. They don't have an existing series of stands that they've taken that they feel they have to maintain. So I think psychologically, the mediator can step in and have a much more of a clean slate. I see it with some clients, especially corporate clients. They're used to running the show. They're used to my word goes. Here's what I say. There won't be any change. There won't be any deviation. And they have trouble backing off positions with their lawyer. And they may not have that problem with a mediator.
And you mentioned mediators with whom you may not be familiar. If a mediator is proposed to you, perhaps in a different part of the country, or perhaps it's a subject matter area that may be relatively new to you, you handle cases in so many different subject areas, what are some of the acid test questions, the due diligence questions that you might ask that mediator? What other due diligence do you do to see whether a new mediator might be acceptable to you?
Well, I do a lot of calling around. One great resource for me is my fellows of the American College of Trial Lawyers. I find that they're very helpful in just about any jurisdiction to another member of the college. And there are a million groups like that. Whether you're a member of a BOTA, all kinds of national associations, there should be a member in the jurisdiction that you can call and ask about the mediator and find out. Sometimes you get bad news. Sometimes you find out, oh, this mediator is a good old boy who's in the plaintiff lawyer's pockets and is going to be proposing these sky high numbers to you. And this is the person all the plaintiff lawyers want because of that. And you may not be as revelatory with that person. You may not be willing to divulge aspects of your case that are going to be harmful, because that person may take them right back to the plaintiff lawyer and spill it all out and do you some damage. So you just have to do a lot of asking around, I think. As far as the acid tests for the mediators themselves, I put more stock in what my compatriots say in that jurisdiction, who've got a lot of experience with the mediator.
Are you in the habit of talking to mediators directly before deciding whether to hire them or not?
Well, it's not, it's not so much deciding whether to hire them most of the time. It's the two sides are proposing mediators to each other and proposing a list. And if you can't resolve it, then either one of the neutral services like ADR or JAMS or Judicate West will make the decision, or sometimes the court will make the decision, and sometimes the court will order you to a specific person or to a specific judge in the court. So you don't always get to choose. But yeah, I like to talk to people before we make a decision about hiring them. If I have that luxury of being able to make the pick, which
or at least screening people who may be on the other side's list.
Yeah, and what I find is that often with the best lawyers, we have common names on our lists.
Mhm.
It tends to be the lawyers who are less experienced or sort of generally not very civil to one another, or are just needlessly adversarial all the time about everything, that we never come up with common names. But I find the better the lawyers, the easier it is. Sometimes our lists are overlapping.
And now my last question, and we'll leave a little time for questions from the audience. Let's talk about the very end of the mediation, the closing techniques. When you need a mediator's help to get that client to pay a little more or take a little less, any general guidance for mediators on what's helpful, what's not, what works, what doesn't at 11:59?
Well, I think a lot of the time, when the mediator says, well, it looks like we can't maybe wrap this up today, but one more session like this and we might be able to get there, is all it takes for the client to say, wait a minute.
It's like traffic school. No, 8 hours is enough.
No, we'll get there. Again, it's so situational. It really is. And a good mediator has a sixth sense about whether somebody is almost there and is just about ready to do it. And it depends on how far apart you are. When you say you're almost there, just a little bit more, a little bit's relative.
Fair enough. We have a few minutes left. If others have questions, please post them in the chat. Jean, perhaps you've been monitoring the chat, or if anyone would simply like to unmute themselves and ask a question out loud, that would be fine too.
I am a mediator. I've been a mediator for going on 16 years. But my expertise is not the law. My expertise is communication, the origins of conflict, prevention and resolution. And so one of the things that I've been doing, and I'm curious about what your thoughts are, hiring a mediator or someone who has mediation expertise to help you prepare your client for the process. Because asking an attorney who has a certain background to also have the ability to work with someone, as you described in the Zoom today, someone who's unreasonable and very intractable and very difficult. What would your thoughts be about hiring a mediator to help you prepare your client for mediation, who is not the mediator who will actually be at the session?
Well, my first thought is that a client isn't going to want to pay for that. A lot of times the unreasonable or unrealistic client doesn't want to go to mediation to begin with, because they're still in full battle mode, and getting them to go is often something that they have to do because the court requires it, and so that's what gets them in the door. But I think hiring somebody a mediator to prepare them for mediation would be a really hard sell for most clients.
Okay, thank you. Kristen Sloan Maccini, please unmute yourself.
Hi, thank you, Jeff, and thank you, Jennifer. This has been really, really enlightening. I wonder if you could comment on any experiences that you may have had using bracketing. When I saw the topic of this conversation about unrealistic expectations, it occurred to me that some of the most difficult situations I found myself in were maybe folks were reasonable, but they were very far apart in their expectations about what they should gain from mediation. I just wondered if you'd use that successfully or unsuccessfully, or any comments you might like to have about that as a technique.
That seems to be getting more and more popular with mediators, to try to use bracketing. The problem is, if they're far enough apart, you're never even going to get the same brackets. I mean, you're going to be fighting over that. So it's just it's another way of saying a range. Would you accept this range? Here's a range I propose. Well, here's the range we propose. Is there, I haven't, it seems to be the latest thing, but I haven't found that it makes all that much difference. If the clients are way far apart, their brackets are going to be way far apart.
Okay,
Thank you.
There's a question in the chat from Andrew Nadolna. Andrew, who Jean, I, and Andrew all do a lot of insurance work, and perhaps this stems from that experience. Any thoughts on what you do or what you've seen mediators do to reach the person who is unreasonable, but not in attendance? And many times, Jennifer, in insurance cases, we have these hybrid situations where some people may be on Zoom, insurance people from far away, 2-3 time zones away or farther, maybe on Zoom, and others are in the room. Any sense of how to deal with the unreasonable apparition?
I think it depends on the value of the case. If it's a lower dollar case, then you're not going to want people traveling from New York to California to be personally present. But you can do the same sorts of things with them, preparing them for the mediation, and then the mediator can maybe have a one-on-one with them in a breakout room, and that's about the only thing I can think of. In a really high dollar case, it's a lot easier to get the decision makers to come. If it's really a case that's worth it in the tens of millions or more, they're more likely to show up.
Okay, Scott Buell, last question to you.
Thanks very much. And first, thanks for an excellent presentation today. One thing that I experience frequently is getting confidential briefs from the attorneys involved, or sometimes a confidential letter on the side. Can you discuss any techniques you might use to convince the attorneys that it's really helpful to share these things with the other side in order to get that other side to see their point of view and maybe be a mind of settling better?
Jeff, I think that's a question for you.
Thank you, Jennifer, and it is a good question. I often find, Scott, I'm urging people to exchange confidential briefs. I read a brief that's marked confidential, and you look at it and you say, what the heck in here is a secret? There's nothing in here that's real. It doesn't seem to me to be a secret. What's up? And people say, well, that's just how we do things. And I may say, well, all right, you can keep it confidential, but then we're going to start the mediation with either you or me basically reading this out loud to the other side. If you want to get credit for your good arguments, the other side has to be made aware of them somehow. And some lawyers relent and agree and will do it, and others won't. And it just means we have to spend a little more time at the beginning of the mediation day making sure that everybody has the most and best information possible on the basis of which to make decisions. And that's what we're up to most of the time in mediation. Jennifer, last comment.
I was going to say you can do both. You can give a non-confidential brief to the mediator, and then you can maybe give a list of it. What it usually is you've got some dynamite impeachment that you're not willing to divulge at this point, but you can show the mediator, here are 2 or 3 things that we've got that are killers. And the mediator can then say to the other side, look, I'm not at liberty to divulge them, but I've seen them and they're killers. And you really have more risk here than you think you do. But you can, the bulk of the mediation brief can be non-confidential.
Okay, we are at the top of the hour. This has been a tremendous presentation. Jennifer, thank you so much for sharing so much, so candidly, in such detail, tremendously helpful both to mediators and to advocates. If people are in a position to do so, please contribute to the Second Harvest Food Bank of Orange County. Natalie has been kind enough to post the website, the link in the chat. We appreciate any contributions. And if you would please let Natalie or Jean or me know about your contribution, we'll be honored to add it to our running total. Jennifer, thank you so much. Natalie, Jean, everybody who is here, thank you so much. And with that, we are complete.